Hello viewers, good afternoon. Today I am with a very important topic and very interesting topic, which will be very perceptive, informative for all those women who are working women, who are working either in big organizations, companies, or in small businesses. This topic is going to be benefited to such women. So, uh, the topic which I'm going to discuss today with you is on sexual harassment of women at workplace. This is the topic of this topic, and we will discuss this topic in reference to the concerned law, which is contained in Sexual Harassment Act of 2013, which came after the on the premise of Vishakha guidelines. Before we discuss uh, the law, I would like to give you the background that what has happened and what is happening in our society. We, our society is yet not very open. It is conservative society. We we see that in our societies there is a lot of gender inequality. We discriminate genders on the basis of their sex, male, female, transgenders, and others. We we continue to discriminate, though the constitution is very clear. Though the efforts are being made, not on the part of the governments, but also the women groups, different NGOs, to bridge the gap of this inequality, gender inequality. Uh, we are we are still very far to achieve the goal of gender equality. For example, we have seen that if male, this problem exists not in the rustic families, the uneducated families, but this problem much more exists in the educated families who live in the cities, who live in metros. This problem exists there, and which is this problem? The we have observed many times that if female child is born, we feel very unhappy, and no reason for that. But we feel very unhappy that a female child has been born, and if male child is born, then we celebrate it. So there are various reasons for this, which still are in existence in our societies, and gradually we are trying to uh, eradicate such issues, such evils from the society. So such type of inequalities, gender inequalities, inequalities are in existence in our societies. The similar things happen when in organizations, in hospitals, in private businesses where the women works, there also they face such problems of gender inequality. So, keeping in view, before this, I will tell you one very important topic, important issue, the story which took place in 1992. There was a in Rajasthan, in small village, Rajasthan. There was a social worker in the name of Bhavani Devi. She was a social worker, and in that area, the child marriages were in existence. Frequently, the child marriages used to take place there, and she always, being a social worker, she has always put efforts to prevent such uh, child marriages. The But it was not liked by the society there, by the male part of the society there, and as a result, what happened to her? That she was gang raped. She was gang raped. Uh, the culprits were arrested. They were put behind the bars. But ultimately, what happened? Ultimately, all the accused persons, they were acquitted. They were acquitted by the court. This, because of this, the sentiments of the people, the public rose. It it raised the sentiments of the public. Media, not in India only, but international media took cognizance of this issue. Women groups, NGOs, they all were raised that it is an example of gender inequality in our society. So, as a result, when these groups were raised, that there are various women groups and NGOs, they constituted a common platform. They constituted a common platform in the name of Vishaka. And a public interest litigation was filed before the Supreme Court of India. Then the Honorable Apex Court, Supreme Court of India, Justice Verma was there in the bench. It was an opportunity for the court to bring something new for the society. So, court took into consideration the international conventions, the norms, and found it significant And also Article 14, 15, 19, and 21. The four articles together, it prohibits such type of inequalities in our societies. So court find the opportunity to interpret law and to bring safeguards to protect dignity and law against the sexual harassment. Then ultimately guidelines were laid down, which later came to be known as the Vishaka guidelines. On the premise of that Vishaka guidelines, the which the Supreme Court laid down, the Parliament of India enacted law in the year 2013, which is called the sexual sexual harassment. I will display that law here in the ticker. You kindly see that. The sexual harassment of, you can see that, of women at workplace, Prevention, Prohibition and Redressal Act 2013. So this was the this was the background of this law, how it came into existence. It started from the story of Bhavani Devi in Rajasthan, which ended ultimately in Supreme Court and by laying down of the Vishaka guidelines. And the role of, we cannot forget the role of women groups and various NGOs, which on the common platform of Vishaka filed this BIL and brought these guidelines and ultimately this legislation in the society. Now we see that gender inequality is still in practice. We have not achieved the 100% gender equality, in which irrespective of gender equality means irrespective of any sex, color, creed, everyone becomes, whether it is the women or the male, all become, or transgender, all become responsible towards and accountable towards each and others. They respect each other. They feel responsible. They feel uh, accountable to each other. There is no tone of inequities between the two different sex, male and female. But we have not achieved in its fullest form till date. Still, we are very far, though we are working on this. Now, this law came into existence, and it has imposed responsibilities on all the workplaces, employers of all the workplaces, between employees. Sexual harassment basically is all about the power. Who exerts the more power? Because this is the power which impacts inside the organizations, and it impacts in various forms. This power, it guides the actions of the others, and if these powers are misused, then it may lead to such inequalities in the organizations, exploitation of the opposite sex. This law prevents the women from this exploitation, which emanates from the power which the other sex has in possession, holds in the organization. So basically, this law prevents all such exploitations. But it is also very pertinent, intrinsic, that the women has to be vocal in this. They have they they have to take off their reticence. They need to come forward to complain about those who misuse their authorities to exploit them. This is very important for the women. And they must know that the women are not alone. A full-fledged legislation protect them. It empowers them to complain about those people in power who exploits them on the workplaces. Now let's examine this law. What this law is. First, you must know. I will take you to concerned section. First, I will show you section 2. There is subclass N in section 2. You can see on the screen. I will widen this. You must know that what can be the sexual harassment is. So section 2, which is the defining section of the Sexual Harassment Act, subclause then defines what is sexual harassment is. First part is physical contact and advances. Number 2 is a demand or request for sexual favors. Third is making sexually colored remarks. Fourth is showing pornography. Fifth is any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. So these are the different categories uh, which shows that if such thing happens on your workplace, then such acts on the part of the person falls within these categories. If somebody physically, if some uh, employee in the organization physically contact with this and advances with this intention to molest, to rage the dignity of the woman, that amounts to sexual harassment. Somebody, if somebody demands request for sexual favors by uttering or in writing, such acts of the person amounts to sexual harassment of the woman at workplace. If someone extending sexually colored remarks, tones in sexually colored tones, that is sexual harassment. If someone in the organization, either it is a hospital, it is a public company, or it is a private company, big organization or small organization or any small businesses where the women work, if somebody shows you the pornography or any other unwelcome, which you feel that this is derogatory, this is unwelcome physical, verbal, or non-verbal conduct, that amounts to sexual harassment of the woman at workplace. So where you feel that such person is trying to advance in such a way that it is unwelcome, it is against the dignity of the women, that certainly that act of the person amounts to the sexual harassment of women at workplace. So you have to see yourself that what sort of fact the person is trying to shower on her. So this is this is about the sexual harassment acts of the persons in organizations. Now Next, which I want to tell you is that what are the what are the redressals available to. I will stop this. What are the redressals available to the aggrieved women under the law? Before this, I will tell you that under the Sexual Harassment Act of 2013, it is the bounden duty of the organizations, whether it is a public organization, whether it is a hospital, whether it is private company of big company or small company, small businesses, where there the women are working. All those organizations, companies, they are within the purview of this act, and it is their bounden duty that the awareness regarding this should be displayed in their premises. This is the duty imposed by this law on the employers, the owners of the organizations, the shops, the private hospitals, the government offices, uh, and the big multinational companies. All it is the bounden duty. It's a legal duty imposed uh, by the legislation to display the awareness regarding this law in their premises and the redressals available to the aggrieved women. So, another which I want to bring into your kind information is that there are two types of committees which are constituted under the uh, under the law. These two committees are the committees where the woman can file her complaint regarding sexual harassment. One is called the internal committee. Internal committee is that committee which is constituted by the organizations. The organizations which I have just explained, like hospitals, private, government, multinational companies, uh, other companies, small businesses, they have to constitute the internal committees, complaint committees, and if any uh, women, working women is aggrieved, then she can file the complaint before that internal committee. And say, for example, if internal committee is not constituted by such companies, offices, then what is the redressal remedy available to the aggrieved woman? The remedy then is then the other committee, which is known as the local committee, local complaint committee, that is constituted by the district officer District officer is the district magistrate of that district. Deputy commissioner, ADMs, to whom you call. So they will constitute the local committee for complaints, for filing complaints of the aggrieved. Suppose if aggrieved woman is not being redressed, then she can go straight to the local committee to file her complaint there. And then it will become mandatory for the local committee also to conduct inquiry, to follow the procedures as laid down under law. So these these are the uh, redressal forums available to the aggrieved woman under the Sexual Harassment Prevention Act of 2013. But again, the problem is that if anything like that happens to any working woman, then she has to come forward. She need not to hide that. She has to come forward to complain about uh, the person who has perpetrated such act on her. Only then we can hope to bridge this gap of gender inequality in the society. If the perpetrators are being punished, and it can happen only if the women come forward when they face such a dire problem wherever they are working. They have to come forward to complain about such culprits so that they could be brought to justice. And if it happens, it will create deterrence. Otherwise, there will be no deterrence. If somebody has committed some act, illegal act, illicit act, then if he is not punished, then it will encourage the act. So it is for the woman to come forward and seek redressals under law. Now, the there are various uh, uh, ways under the law provided that if the action is taken, then what procedure is to be followed, what the forum will do. Conciliation is there. If conciliation is failed, then inquiry starts and police is directed to file FIR against the culprit under Section 509 of Indian Penal Code. So this law has teeth, but it could be used only if women come forward. They complain about such acts of violence on them. So this is what the sexual harassment is. And summing this up, I will exhort on that the women must redress their grievance if they face such harassment on any workplace where they work. But one thing which I want to make clear, and I want to make the women cautious that the complaint should be genuine. It should not be malicious. It should not be filed keeping in mind the malice against the opposite sex. It must be genuine, and because if the complaint will not be genuine, then action against them can also be taken under law. There can be malicious prosecution against such women who misuse this law. With this, I will end my this episode, and hopefully it would be perceptive, informative for everyone. With this, I will end my this episode. Say goodbye. Thank you very much. Have a good day. Thanks.